Brigadier, we were about to start on the APIS acquisition for the Vereniging and Bramley cases at paragraph 39. And can you take the Commission through the process by which the Vereniging, first the Bramley case was put onto ABIS? It's what you address in paragraph 39.
Thanks, Commissioners. Commissioners, on the 6th of September 2024, the samples which were analyzed by Captain Mahotle were acquired on IBIS system by Warrant Officer Modise. She used the ballistics lab number 193045 of 2024 belonging to the Bramley case. As per standard procedure described earlier above, an IBIS lab number ought to have been generated for the acquisition of these samples. However, due to the agency in processing the ballistic analysis, Captain Mahotle requested for acquisition of the sample prior to case management section generating an IBIS lab number. And as a result, the case was acquired without generating a IBIS lab number. Hence, it was acquired using the ballistic lab number. I attached the images from the IBIS system which were printed out, indicating the images which were acquired on the 6th of September 2024, marked as Annexure MNM1.
Brigadier, we've already gone to those images, but maybe if we can just quickly go back. It's page 1 of the Annexure bundle. And first, can you just point the Commission to where the case number is, under which it's acquired on the system?
Commissioner, on page 1 of 1, under the case number PTA 193045/2024 in brackets 1. That is the lab number of the Bramley case 149 of 4 of 2024. At the top where it says case details.
And if I understood your evidence correctly, that is the PTA 193045/24 number is the number that was assigned to it by the FSL registration and not the ABIS registration. And ordinarily you would have an ABIS registration number there as case number, but the FSL number was used in this case.
That is correct. That is correct, Commissioners.
And then to go lower down, if we look at the creation date under cartridge case exhibit details, or even the case details, let's not go low down. The creation date under case details, it's 9/6/2024 at 11:01:33.
That is correct, Commissioners.
Which would be 6 September on the North American dating system.
That is correct, Commissioners.
Then if you go to paragraph 40, you talk about this period of 24 May to 6 September. Can you just address the Commission on whether this just over 3 months, 3.5 months actually, period from the conclusion of the affidavit on 24 May and the entry into the system on 6 September is an ordinary time period, a quick time period, a slow time period?
Commissioner, if we may just look this in conjunction with a paragraph which is still coming, where the specimen was eventually registered at IBIS. given an IBIS lab number, one will realize that had this specimen followed the normal procedure by following the queue, it would have been acquired around December if the member did not request that it must be expedited, because we have records that it was only registered on the 3rd of December. Sorry, my apology for that. It was only registered on the 2nd section. It was only, the lab number was created on the 8th of November 2024. That is on paragraph 41. So if you check when it was acquired, then it was acquired on the 6th of September 2024, not after being registered. After being registered, it was only registered on the 8th of November. So if one can conclude that it would have only been acquired in December if it followed the normal conveyor belt as I explained it to commissioners.
But I mean, I thought the question was, unless I misheard it, is to try and get an explanation for the lapse of time. So you've got the Section 212 affidavit at the end in May 2024, and and then you say that Captain Modise, I think it is, gets this. You say then on the 6th of September, the samples analyzed are then acquired by Officer Modise. The explanation for the lapse of time between the end of May and September, and considering that this is being done on an expedited basis, what's the explanation for that?
The only explanation is that upon handing it for IBIS acquisitions, we only have the date that we are working on, which is the 24th of May 2024.
Sorry, can I just intervene here, because 24 May is when the 212 was signed, but the completion at FSL was actually 6 June. So the reviewer signed off and completed on 6 June. So it's exactly 3 months, from 6 June to 6 September. And the question really is, why would it take from 6 June to 6 September to enter the ABIS system?
Yes. Through my analysis of precisely that, because it was also a concern from me that if you requested it to be expedited, then why 3 months only later? So when I listen to the explanation and look into the events, how they unfolded, I could understand. I mentioned about a bullet which was retrieved from the deceased, which was sent to the lab. I may just refer back on the 12th of August, 2024. What seems to have happened here, along the way, immediately when the member completed the case on the 24th of May, 2024, at that point, there was not much pressure coming from either the investigating officers with regard to the agency of the case. We know that there was a murder, it was treated as a murder like any other murder. So along the way, calls started coming when the bullets came. So during that period when he completed it, it will seem that that was later on, immediately the bullet came. So he waited to finalize the bullet in August. And when he handed over for acquisition, which took place on the 6th of September, it was after he has completed the examination on the bullet, which was received on the 12th of August. So that was the explanation which could address as to why that period.
But Brigadier, that can't be the explanation because the bullet comes in August, but the 212 in relation to the bullet, if I remember correctly, was dated 14 October. So he'd actually entered the file into ABIS on 6 September before he completed his ballistics examination in relation to the bullet. We'll get a copy of that 212 from the case file, but I'm fairly certain that the data of if we go back to the entries that you discussed earlier,
Is it in 37.3?
I beg your pardon, Commissioner?
I'm saying, are you looking for paragraph 37.3 on page 17?
The third entry, indeed. The entry only gets assigned to him on 11th of October, and he issues his 212 on 14 October, and the entry is completed on 23 October. So the bullet happens after ABIS acquisition on 6 September. You do address, if you look at the top of page 19, you speak to a bottleneck that we actually didn't address earlier, which you address in paragraph 40 at the top of page 14, which is, well, maybe if you can just consider that paragraph and maybe read for the Commission what you state in that sentence that says in this regard.
Just paragraph again, Commissioner.
It's paragraph 40 of your affidavit. Starts on page 18, but it seems to me that the critical point is the last few sentences of that paragraph, where you deal about the bottleneck on getting into ABIS just for registration, not for acquisition by the system.
The one we start with turnaround times.
Let me take you to this point that you make. You say that the ABIS system at head office receives on average 1,700 samples per month to enter into ABIS. With a current full complement of ABIS analysts working full-time on the process, the section has the capacity to enter approximately 1,300 samples per month. So the existing backlog at head office is continuing to grow at the rate of approximately 400 samples per month. Now, what are you talking about here? Is that acquisition on the system, or is it about simple registration at ABIS? What are we talking about there?
Thanks, Commissioner. Yeah, on this paragraph, I was referring to the actual acquisitions of the specimens after all the administrations has been completed.
I hear you. So that issue there, 1,700 samples, an increasing backlog that increases by 400 per month, deals with acquisition, which is what took place on 6 September 2024.
That is correct, Commissioner. That is correct.
And is there any way of, if you want to fast track an individual file, is there a way of getting your file acquired sooner than 3 months?
The only way is when you jump the queue and pressurize whoever is available to acquire it as speedily as possible, but you'll have to jump the queue, commissioners.
But on what you say in paragraph 39, Captain Mokgotlo did actually jump the queue. Because if he hadn't jumped the queue, we wouldn't have a ballistics lab number, 193045, in the ABIS system. We would have had the regular ABIS lab number that was eventually assigned on 8 November.
That is correct, Commissioner.
So he jumped the queue, but he jumped the queue after 3 months, as it were.
Yes, it's also something which, like I said, I also had to apply my mind and see what actually happened. But in reality, if you check the flow of work coming, it is possible. And when you consider when the case was eventually registered under normal circumstances.
Can we then move to the acquisition of the ABIS lab number? And that you address in paragraph 41.
As indicated above, the Vereeniging and Bramley samples were acquired in the IBIS system prior to an IBIS lab number being generated by the case management section. However, the case management section still, at a later stage, generated lab 5655427/2024 on the 8th of November 2024. I referred to this earlier on. And
Can I ask, how would that have happened? We've got Captain Mahotlwe bringing the file and jumping the queue in September. How would an ABIS lab number then get, how would the file go back into the system so it gets an ABIS number? What physically would have happened?
Commissioners, the case files are managed by case management section. Once a case has been finalized, it goes to case management, either for dispatching, scanning of the 212 report and dispatching of the exhibit, and for archiving. Because for the IBIS lab number to be generated, a sticker must be affixed on the front page of the case file on the far right. So if this is a ballistic case file, for example, you will have one sticker on your left and one sticker on your right. The sticker on this side will be the ballistics with the lab number, and the one on the right will be the IBIS lab number. So as they process those case files, they will check the one that do not have the sticker. According to them, it means there is still some work outstanding. It means they must still generate an IBIS lab number on that particular case files. So the only logic is that once the member who acquired the specimen under the ballistic lab number, once she is done, she returned the case file to case management. But because there was no explanation, case management saw it as like all the other cases that must still go to IBIS for registration. Hence, they generated a lab number on the 8th of November 2024. That lab number, then, therefore, because there was a lab number of IBIS, it has to, again, follow the process to be acquired. And only then, when the operator was supposed to acquire, when she opens the case file, she realizes that this case has already been acquired on the IBIS system. She then...
Can I just stop you there? This case officer would then be Warrant Officer Shihlangu. Is it pronounced Shihlangu or Sihlangu?
Shihlangu.
Sihlangu. I was several of your experts, not your experts, your officers yesterday were using Shihlangu. So Warrant Officer Sihlangu gets this file again on 2 December 2024. How would she, at that stage, know that it's already gone through the ABIS database?
Commissioners, there is a log that is attached inside the case file, which keeps record of the dates, still back that are open, events. So it's like a diary that is attached inside the case file, where you record everything that is happening with that case. So obvious, when you open, surely you should have seen, you could have realized that there's records that a seal bag was open and the specimens were acquired. Therefore, I need not proceed with this case.
If you can then continue.
The person who generated this lab number, I've explained this, did not have sight of the fact that the samples had already been acquired on the IBIS system. And then on the 2nd of December 2024, the same lab number, 565-427 of 2024, was assigned to Warrant Officer Sihlangu. We have already explained this for acquisition purposes. Upon realizing that the specimens for the Vereeniging case were already acquired on IBIS through ballistic lab number 193045 of 2024 related to the Bramley case, she did not proceed with the acquisition of these specimens, as the specimen already existed on the IBIS database. She then took the case to Warrant Officer Mbiza for review. She's responsible for review. And on the 3rd of December, Warrant Officer Mbiza then cancelled the number 565427 of 2024 on the FSL system. And the reason given in the system reads incorrect registration. So, Commissioners, what was cancelled was an entry on the FSL system, which was not supposed to have been created in the first place.
And if you can just explain that, why wasn't this entry 56427 of 24 one that shouldn't have been created in the first place?
In the first place, because the specimens were already acquired using the ballistics lab number. So if the members had sight to that, they could not have proceeded to register a lab number again.
Can we then just look at the registration screenshots that you attach as Annexure MNM2 from page 11 of the Annexures file? And can you describe what we see on the first page of that annexure, page 11?
Commissioners, this is a printout from the FSL system, which contains the records of this particular case. It gives you the lab number of the case, the entry number, and the person to whom the case was assigned to. And then it gives you the details of the section IBIS. It also gives you the reason why the case was cancelled, and the comment cancelled, then the reason why it was cancelled.
And then if we go over the page?
When you go over the page, it's another window that you open on the system. It gives you the lab number of the case, the person to whom the case was assigned, the section. Now it gives you all the details. Now, the date when the case was registered, the date when it was assigned, and the date when it was completed, and the reason for completion, and the person who completed it on the system.
And there we see that cancellation is recorded as having been completed on 3 December 2024 by Mbiza.
That is correct, Commissioners.
And the third screen on page 13?
This is just the same window, but in a magnified, and it does not give it does not give the entire information, but it's the same window print out, Commissioners.
Can you then describe the entries that are recorded on the FSL admin system regarding the Bramley and Vereeniging cases in KZN? Because you spoke earlier of entries not just at head office, but also at KZN.
Commissioner, at a later stage, the system will show that the Bramley case was then referred to KZN for further examination. When it arrived in KZN, they generated a new lab number, lap number 469673 of 2024. This case was registered on the 13th of September 2024 in KZN. And it relates to the exhibit firearms which were recovered from the Bramley when the suspects were arrested. And this entry was then assigned to Warrant Officer Kaida. He is stationed in KZN Ballistics. He finalizes the case on the system on the 4th of October 2024.
And the Vereniging case?
The Vereniging case, again, it was also sent down to ballistics in KZN, and a lap number was generated for the same case, 634383, which was generated on the 10th of December 2024. This was relating to firearms, and the entry was assigned to one Captain Mkachwa on the 11th of December 2024, and it was finalized. It was Captain Mkachwa must just state that he was deployed from our office to assist the political killing task team in KZN at that time. The system was finalized on the system on the 7th of January 2025, Commissioners.
And the ABIS acquisition in KZN?
Commissioners, the Vereniging and Bramley cases in KZN were also acquired on IBIS system. A lap number 469673 of 2024 was generated for the Bramley case in KZN, and it was acquired by Warrant Officer Mkhize from KZN using lap number 507815 of 2024. On the 16th of January 2025, the Vereniging case with lap number 634383 of 2024 was again acquired by the IBIS in KZN on the following lap number 16554 of 2025 and acquired by Warrant Officer Mzimela.
And the ABIS number for that acquisition?
It is 16554 of 2025, Commissioners.
And those are the only entries in the audit trails on the FSL system and the ABIS system. Well, if we go back, from paragraphs 41 to 48, you have described all of the entries on the audit trail of the ABIS and FSL system for these two files.
In KZN, yes, Commissioner.
No, because if you go back to 41, sorry, you're right. I need to take you further back. It's from paragraph 33 on page 15 to paragraph 48 on page 21. You've described every single entry on the audit trails on the FSL and ABIS systems for these two cases, be it in head office or KZN.
That is correct, Commissioners.
And to the best of your knowledge, it's not possible to tamper with those audit trails.
Not possible, Commissioners.
Advocate Chaskalson, can I ask you a question here? Brigadier, if the system in Pretoria works so well, why did the two cases end up in KZN? What's the reason for that?
Commissioner, it's a question that I'm also asking. I'm asking myself that question, Commissioner. And I do not have an answer, Commissioner, because myself, as the custodian of cases in the head office, Pretoria, if there's any request, it must go through my office, and there must be a reason. If the client is not happy with my service, I've got a procedure to attend to client's complaint. So if it was because there was some unhappiness, there's a procedure to deal with that unhappiness. But in this instance, it only came under my attention at a later stage that cases were, in actual fact, being committed between the two labs on a regular basis. So I cannot give an answer as to what was the reason for that, Commissioner.
If I remember the evidence of the investigating officers, it was suggested that at least in the affidavits, there were some omissions, either deliberate or negligent, I cannot remember. And the ballistics reports were not done properly. Hence, it was resolved that the cases be taken to another lab in KwaZulu-Natal. Are you aware of that?
I only came aware after this year, and I attended to it. I'm sure it's in my statement. But we have a procedure. If that was the case, it happens, then we deal with it. So if that was the reason, but I was not informed when they were taking them as to what was. I only find out when it was brought under my attention that those cases were in KZN. That is when I happened to know about that. Okay, those cases, Commissioner.
Are you aware that in the 1112 affidavits, there were omissions relating to, I think, the 15 cartridges that were recovered in Bramley?
Commissioner, I'm aware that there were typos, type errors.
No, not typos, omissions.
Commissioner, I would like to explain, if I may be given an opportunity, what we said to the commission, what were they? I will have to refer to the statements because that it will explain exactly what happened. If I may just given leave to open that statement, Commissioner. It will be the evidence leader, it will be MMN4, annexure MMN4.
That's the report on a non-conformance report.
That's correct, Commissioner. And then you go to the statements.
Okay.
On page 25.
On page 20. So this document, can we just explain to the Commission what this document is? So to start off, you've just confirmed it is a non-conformance report. When was it produced?
Commissioner, the non-conformance.
Yes.
Commissioner, it's in my statement. There was an incident and I was visited by the investigators on the 8th of January 2025. I'm sure I'm ahead of the evidence leader on this one. 8th of January 2024, which is covered in my statement on page...
It's page 24.
Yes.
And what was their complaint to you?
Commissioner, their complaint was that they came to look for a statement which they've discussed with the analyst. Their concern was that there were omissions of results in the statement. I then asked them to give me a copy of that statement. Upon perusing the statement, which is on page, which is the one which start on page 18. I realized that it was a statement.
Can I take you back, Brigadier? It seems that their complaints were you've raised a complaint about omissions in the results. There are other, I mean, if one looks at the top of page 25, there are other complaints. There's a complaint about discrepancies in the initial affidavit, which would be the May 2024 affidavit, and the backdating of the amended affidavit that sought to address the initial problems. So
That
there
is
were,
correct.
and there was an underlying complaint also about an omission of results, an omission of reference to other matches or other hits. Is that correct?
That is correct, Commissioner.
What was your response to these complaints?
I requested them to produce the report, which I went through in their presence. And indeed, I could see that there were typing errors.
Why do you describe them as typing errors?
First thing, commissioners, I will go to the pages. When I checked, because they were saying that the findings of the 15 cartridge cases of AK-47 were not done. There was no reference to those findings. So I said, then I checked the statement. The first thing that I saw, I wanted to see if in the statement, did the analyst did the work? So when I checked on paragraph 10, firstly, under the microscope, maybe I will take the commissioner slowly so that they can understand, because you won't see it immediately. If you go to paragraph 10, I will read it for the record. I examined the fired cartridge cases.
Sorry, Brigadier, just because we're going to look at least two versions of this affidavit and possibly a third, can you just indicate where you're reading from? And I think you're reading from page 25 of the annexure bundle.
That's correct, Commissioner.
And that is a copy of the original report that was furnished in May 2024.
That is correct, Commissioner. I examined the fired cartridge cases and bullets mentioned in paragraph 3.1, paragraph 3.4, paragraph 4.9. I've cycled 4.9. I'll come back to that. Paragraph 4.10, paragraph 4.11, and tests mentioned in 7.2 and 7.5, and compared the individual and class characteristics markings transferred to them by the firearm components during the firing process using a comparison microscope, and found, I'm going back to that 4.9. If you go to the statement and check the exhibits mentioned in 4.9, I'll give the paragraph now, 4.9. 4.9 on page 23 is the 15 7.62 by 39 millimeter caliber fired cartridge cases, and mark them AA3A to AA30. Now,
Can I just stop there, Brigadier? Those are 15 AK-47 cartridges in the Bramley case that were found in possession of the suspects when they were arrested in Bramley.
That is correct, Commissioner. Now, when you go back to that paragraph that I read, 10, the analyst is telling you that I compared these cartridge cases with the test which are mentioned here. Now, let's look at paragraph 10.2 and 10.6 simultaneously. 10.2 and 10.6. If you check it says, the cartridge on 10.2, the cartridge cases mentioned in 3.4, I've cycled the 3.4. You go to 10.6, He says the bullet core mentioned in 3.4. Again, so you've got 3.4 there. That tells you that you've got a problem. Now, when you go to 3.4 to see the description of the exhibit in 3.4, 3.4 describe the exhibit as two 7.62 millimeter caliber fired bullet cores and mark them lap number AA3 and AA9. Those are bullet cores. So the findings of the bullet core is in 10.6. He says the bullet cores mentioned in 3.4 are not suitable for microscopic comparison due to damage. So we know that those core are unsuitable for comparison. So if we go back to paragraph 10.2, he started the sentence by saying the cartridge cases mentioned in 3.4. We have already dealt with 3.4, and we know it's not cartridge cases. Those are bullets. And they are unsuitable for microscopic comparison. But this paragraph says, these cartridge cases mentioned in 3.4 were fired in the firearm mentioned in 4.1. We go to the description of the exhibit in 4.1. It says one 7.62 by 39 millimeter caliber AK model 47 assault rifle with serial number 575363 with 4 magazines. He's saying now, these cores mentioned in 3.4 were fired by this AK. And we know now that there's no way you can compare them because they were unsuitable for comparison. So the mistake is glaring. And now, can it be interpreted? Can it be interpreted as tampering? I say I have a procedure in place to investigate when we come across such incidences. And the procedure is to register a non-conformance, investigate. The investigation will tell you what happened. And in these instances, commissioners, upon receiving this complaint, I immediately embarked on that process to have this matter investigated. We registered a non-conformance, which is also attached under the same annexures. And through the investigation, we end up retrieving this report because it's wrong and replacing it with the correct, where there is reference to these 15 cartridge cases and the AK-47. Hence, I'm saying only through the investigation you can tell whether the mistake was deliberate, tampering, but it was investigated and corrective actions were implemented, commissioners.
Let's just to be clear, the mistake in 10.2 on page 25. 10.2 should have read as follows. The cartridge cases mentioned in 4.9 were fired in the firearm mentioned in 4.1. That's how it should have read.
That is how it should have been read,
so
commissioners.
The 15 cartridge cases in paragraph 4.9 were omitted, or there was an error there, however you want to characterize it.
I had to go further to check the comparison mic form in the case file with the handwritten notes. I noticed that in the microscope, the member confirmed the cartridge cases in them, and he has written notes that these 15 cartridge cases were fired from this firearm. So the only question is when he transferred the results into the affidavit, he made an error with the paragraphs. That was my explanation. That's my explanation, commissioners.
It seems to me there are two possibilities. The one possibility is it was a sloppy error, that in recording what happened to the cartridges that he mentions, cartridges and bullets mentioned in that first line of paragraph 10, warrant officer Makgotlwe, instead of writing 4.9, wrote 3.4 and just got the cross-reference wrong. That's the one possibility. The other possibility is that it was deliberate, and it was an attempt to sabotage not the investigation, but the prosecution. But I want to interrogate the second possibility, because that is certainly how it was perceived by the investigating officers. But it seems to me that if you were going to sabotage the investigation or the prosecution this way, it would be rather strange. Because if you look at what else he says in his reports, bear in mind that what he should have said in 10.2 is the 15 cartridge cases that were found in Bramley, which wasn't the crime scene of the murder, were fired in the AK-47 seized in Bramley. That's what he should have said. Instead, he said something that ultimately is clearly self-destructive. But look at what he said in 10.1. He said the bullets mentioned in 3.3, and if we go back to 3.3, the bullets mentioned in 3.3 are AK-47 bullets retrieved from the scene of the murder. You'll see that at page 22. They're in the Vereniging file, and it's paragraph 3.3. So he positively confirms that the AK-47 bullets at the scene of the murder are fired from the AK-47 that the suspects are caught with. That seems to me the single most important finding in relation to the AK-47 in terms of linking the suspects to the murder in Vereniging, and that he confirms. But he goes further. He mentions in 10.3 the cartridge cases mentioned in 3.1, that's the Parabellum, the 9mm cartridge cases found at the scene in Vereniging, and 4.11, that we see at 23. That's one fired cartridge case found in Bramley. So both cartridge cases found both at the murder scene in Vereniging and at the arrest in Bramley are fired from the firearm mentioned in 4.7, which I think is the Taurus firearm, which was seized from the suspects. Again, if you're looking to sabotage the prosecution or the investigation, it's strange to tie the suspects to cartridge cases found on the scene of the murder and a cartridge case found in their possession at the time, because that would definitely link them to the murder scene. Then similarly, 10.4, the bullets mentioned in 3.2, these are 4 9mm caliber bullets found on this murder scene at Vereniging. He confirms that they are fired from the firearm in 4.7, the Taurus firearm. So he has tied the suspects to the murder scene with his conclusions in respect of the Taurus and the AK-47. What he hasn't done is tied the gun in the possession of which the suspects were found to cartridge cases that were also found in their possession at the time. It seems to me that of all of the findings that one would need to convict these people, the one that is of least value is to show that when you arrest them and they're carrying empty cartridge cases and a rifle, the empty cartridge cases were fired from the rifle. You know that they had both the empty cartridge cases and the rifle at the same time. That seems to me the least important of all of the conclusions, and that's the one that he got wrong. So it does seem to me that viewed in isolation, this error certainly doesn't, of its own, point to a deliberate attempt at sabotage. But there are other mistakes that may make the situation different. So let me take you to.
Don't you want the witness to
Well,
comment?
can you comment on what I put to you in relation to whether this is deliberate sabotage or just a sloppy error?
Thank you, Commissioners. My emphasis on the 10.1, the bullet. In the ballistic language, when one is able to link a bullet with a firearm, that for us is a big plus for the case as compared to the cartridge. I'm not undermining the cartridge cases, but the bullet in most cases is removed from the deceased. So if you can be able to link the firearm to the bullet which was removed from the deceased, you have undoubtedly placed the firearm on the scene. And under these circumstances, this is what the member has done. And I'm sure if he did that with a mind to sabotage, his brains needs to be examined. There's something wrong with him, because the evidence suggests otherwise, Commissioners.
Well, I just need to correct you on one issue there, Brigadier. These bullets were found on the scene, but not in the body of the deceased. Remember that the bullet in the body of the deceased is the subject of a separate report on the 14th of October. But for the record, I mean, we will look at that report with Captain Mkachwa. But for the record, that report, also prepared by Captain Makhotle, confirms that the bullet taken out of the body of the deceased was linked to I think it was the AK-47, may have been the Taurus pistol, but we'll deal with that with Captain Mkachwa tomorrow. These bullets were bullets picked up on the crime scene. They weren't recovered from the body of the deceased.
Mr. Chesterton, if you're moving on, can I just ask on this?
I'm not moving on from the report as a whole, but I'm moving on from this section of the report.
That's my question. Thank you. Brigadier, and it's really me trying to understand, to follow your evidence, the cross-referencing that you're doing between the different paragraphs 3, paragraph 4, and then where the findings are made. What does it mean that in paragraph 3, for example, he says, I received an intact sealed evidence bag with, and then he gives a number, right?
Yes.
And then he describes what he found in that number, and as I understand it, of interest has been 3.4, subparagraph 3.4. And then you go to paragraph 4, it's a completely different bag where he describes what's in that bag. It's a different number. And he describes what he found there. And in fact, in particular, 4.1, he says a sealed evidence bag, which is something that we're discussing now, and he gives a number there in 4.1. And then you go to 4.9, it's a different number. Now, given the cross-referencing where you were referred at page 25 to 4.9, and you've done the cross-referencing to show us that, in fact, he did do the examinations and he's accounted for them, what does it mean that there are different numbers to this? Because in my mind, it suggests he had different specimens in sealed evidence bags.
That is correct, Commissioner, because these were two cases.
Yes.
He had the Bramley case and the Vereeniging cases, and each of the exhibits were packaged separately in a tempered seal bags. So he was referring to those seal bags as he opened them and as he received them, Commissioners.
Yes. So 4.9, as I say, it has its own bag number, right? It has its own sealed evidence bag number. Where does one see from your explanation that he's made findings about what was in that bag, which has a number ending 207?
I read paragraph 10 where he is now giving his findings.
Yes.
And in that paragraph, that's where now he referred to all the microscopic comparison that he was doing, he was conducting, and he made reference to that paragraph 4.9, which tells me that it was part of his microscope work on paragraph 10. I said he mentioned all the paragraphs with cartridge cases, bullets, which were supposed to have been compared with the test. And that 4.9 appears on that paragraph. It means he worked on it as well.
So do you say 4.9 appears in paragraph 10?
Paragraph 10, yes, Commissioner.
Where in the findings in paragraph 10 does it appear?
He starts with a preamble
Yes.
of what he is going to do.
Or of what he examined?
Yes, yes.
And then from 10.1...
Then from
up to
10.1, it started to be now specifics.
Yes, and that's the part I'm not understanding, and it may well be it's me, where you say he has made findings about the specimen in paragraph 4.9, right? So he says, I examined 4.9, the casings or the cartridge cases that are in paragraph 4.9. And then one goes to 4.9 to see what is in 4.9. And what you find in 4.9 is 15 7.62 by 39 caliber fired cartridge cases. So we know that's what is examined, and that's what he tells us in the first line.
Yes, Commissioner.
And then my reading of the rest of that paragraph 10 is from 10.1 to 10.6. He then tells us what findings he made in respect of those cartridge cases that he examined.
Yes, Commissioner.
What I'm not understanding is where in this 10.1 to 10.6 do you say he makes findings about what is described in 4.9?
Thanks, Commissioner. That is where I was referring to paragraph 10.2 and 10.6 and said that he referred to 3.4 in paragraph 10.2, and he also referred to 3.4 in paragraph 3, in paragraph 10.6. Then I said, it doesn't make sense that he will refer to the same paragraph in two different findings. He can't say in paragraph 10.2, cartridge cases mentioned in 3.4. And again, he can't say the same with paragraph 3.4 in paragraph 10.6, the bullets cost mentioned in 3.4. That in itself is a problem because it tells you 3.4 on paragraph, how possible is that you compare these exhibits in 3.4 and you made findings in two different, you made findings on the same exhibit twice. So the only explanation is that on paragraph 10.2, it was supposed to be 4.9 as opposed to 3.4. Because we now know that 3.4 are not cartridge cases. 3.4 refers to bullet core. And we are saying that those bullet cores were unsuitable for microscopic comparisons. So if you refer to the 3.4 in 10.2, definitely that is a mistake. As to how do you attribute that mistake is something else. That is what I was saying, Commissioners.
And the reviewer missed the mistake. I'm assuming the 112 was reviewed. So, sorry, 212.
That is correct, Commissioner.
In terms of the process you described this morning, you said these statements or affidavits would be reviewed. So are you saying the reviewer also missed that mistake?
Commissioner, when I checked the case file, the review checklist was signed by a reviewer. So no doubt the reviewer also missed this. And not only this one, they also missed, if you check on paragraph 13.5, instead of saying 24 March, May, they say 24 March. 13.6, instead of saying 24 May, he says 24 March. So both the reviewer and the member missed those mistakes, Commissioners.
Brigadier, in fairness to the reviewer, we've seen the case file. Again, it was something I was going to address with Captain Mkachwa. The reviewer actually did not sign off on this file, on this report. The reviewer was asked to sign off and circled no, and gave a set of instructions of errors, and cross-referred to errors that she had put in the Vereeniging case file, indicating what had to be corrected. So the reviewer, in fact, wasn't at fault here. The reviewer identified errors. But the question still remains, how did this report go out when the reviewer had said no and errors were not corrected? The reviewer didn't sign off a second time. It's an issue we'll deal with through Captain Nkachwa tomorrow. But there are other issues that I'd like you to, sorry, but just to get back to Commissioner Baloyi's concern. It's correct. I mean, everybody agrees that the reference to 3.4 in paragraph 10.2 is a clear error. It's contradictory for several reasons. One, 3.4 is not cartridge cases, it's bullet cores. Two, the bullet cores are stated in 10.6 not to be suitable for microscopic comparison because of damage. So if they're not suitable for microscopic comparison, you can't link bullet cores to a firearm mentioned in 4.1. And then also you'd never have two different findings on the same bullet cores. And the one cross-reference which we don't see in 10.1 to 10.6 is the cross-reference to 4.9. To pick up on Commissioner Baloyi's query, and just to clarify what you said earlier, but what might not have been fully understood, is you have inspected the working notes of Captain Makgotwe. We don't have them in this file, but you have inspected them, and what you saw, you just testified, in those working notes is that he did make the match from the cartridge cases in 4.9 to the firearm mentioned in 4.1. So his working notes reflected that match. And just to complete that picture, when he was asked, I think we've had evidence thus far, it's an annexure to General Khumalo's case. The prosecutor pointed out the discrepancy in 10.2, pointed out the fact that the cartridges in 4.9 were unaccounted for, and asked him to correct his report accordingly. And if we go to page 33 of the same folder, when he was asked to correct his report, he corrected it to confirm that 10.2 he included the reference to 4.9 in 10.2. So we do know that what he should have put in there was 4.9.
That is correct, Commissioner.
You've mentioned other errors in the report. You've mentioned the references to March instead of May in 13.4 to 13.6. In fact, you've got the same mistake at paragraphs 13.2 and 13.3 on page 25. None of those mistakes strike me as evidence of sabotage, but there is another mistake which may well be evidence of sabotage, and I want to take you to that. If you go to paragraph 4, in paragraph 4, what you see is he states the following. On 24 May 2024, during the performance of my official duties, I received an intact sealed evidence bag with number, and he gives a number, marked inter alia, Bramley case 140/04/2024. Now that number that case file number is the wrong number. The correct number is 149. And I want to put a scenario to you. I may be wrong, but I want to put this scenario to you. The way that criminal prosecutions ordinarily proceed is in advance of the trial, the prosecutor draws up a list of admissions that it wants the defense to make. It says, I want you to admit A, B, C, and D. And in a case like this, on that list of admissions would be the correctness of the ballistics report of Captain Magotle. If the defense makes that admission, no one is called to court to testify in relation to ballistics. And the state closes its case, relying only on the ballistics report of Captain Magotle, which is not disputed. Now, it is certainly arguable that if the defense has done its work closely and has spotted this mistake, they will say when the state has closed its case, or when they argue at the end, that none of the weapons seized can be linked to our clients, to the accused, because the evidence bag that the report speaks to is an evidence bag marked Bramley case 140/04/2024. And our accused case is Bramley case 149/04/2024. So you haven't shown a chain of custody from the scene to the ballistics examinations. So what we see in paragraph 4 may be a typing error. It may have been, instead of typing 0, he typed 9. They're next to each other on the keyboard. But it may also have been a quite sophisticated attempt to sabotage the prosecution. What's your comment on that?
Commissioners, I will explain this according to our procedure, our processes, not taking away what the council has indicated. When you read what that paragraph says, it says, on the 24th of May 2024, during the performance of my official duties, I received an intact seal evidence bag with the following number, marked inter alia. In our environment, that inter alia, analysts are taught that they must write it as it is. If the investigating officer has written a wrong case number, you document it as you see it, inter alia, as you see it on the package. So I see here the case number is wrong, but without having the advantage to see the seal back and see what was it written originally, I cannot comment whether the member did that with the purpose. But I'm just saying that if it is marked wrongly, you marked it, because we have come across the same argument in court where the defense will say the bag that you received was marked this inter alia. And you, knowing the correct case number, you write it according to how you know the correct case number. They take issues with you as well, because they say you have now tampered with the chain of custody. That is not how you received it marked. You received it marked with this case number, but you wrote the correct case number. So it will be interesting to see in the original seal bag, how was it written? That is my comment with regard to that issue, Commissioners.
And that original bag, as I understand it, should be still stapled to the ballistics folder for the Bramley case.
That is correct. We do that, Commissioner.
So we can, Captain Kachwa, I think, has that file, and we can we can investigate that with him tomorrow.
That is correct, Commissioners.
May I just ask Mr. Chistelson, does it mean, Brigadier, that from what you've explained, that you know the correct case number, but the evidence bag has got a different case number? Does it mean that your processes do not permit for inquiry with the investigating officer? So let's assume what you've said is what happened in this case, because clearly we know from the report that Makotwe knew the case number, because right at the top of page 22, there's Bramley Cas 149. So he must have known the correct case number. If he received the evidence back with 140, saying the case number is 140, do your processes not require that he makes inquiry or permit that he makes inquiry with the evidence leader, with the investigating officer?
It does, Commissioner. If, for example, here, on the covering letter, the case number was also wrong, then in that instance, it means we are dealing with a different case number. But what I say, you write, you document it as it is. Sometimes you'll find out other investigating officer, for example, he may start with the case. He may not write the name of the station. Maybe write case number 140 of 04-2024, omitting the station name. You may not add the station name, even if you know that it's Bramley, because that's how it's written on the covering letter. But if it's a mistake that affects the case, which in any way it is a wrong case, in that instance, we contact there's a form, there's a procedure, there's a statement that you complete, depending on whether you noted that mistake once we have opened the parcel or before. Then we return it back, or we will make means to contact the investigators to come and correct and explain. But in this instance, it's a mistake, but it is, according to this paragraph, you document it as you see it. Hence, I'm saying this can only be ventilated when we see the sealback.
Can we then turn to the corrected affidavit, which starts at page 28. And if we look at page 28, or if we look at page 30, we see that in the corrected affidavit, the reference to, in paragraph 4, the reference to the Bramley case number is still 140 as opposed to 149.
That's correct.
When we go to paragraph 10, we see that the error in relation to the cross-reference has been corrected. So the 10.2 now refers to the cartridge case as mentioned in 4.9, which is what it should have referred to all along. And if we go to 13, we see that the errors on the dates still remain. And that's true. The wrong references to March are in 13.2, 13.3, 13.4, 13.5, and 13.6. But if we go to the signature page on page 35, we see that the date of the signature still says 24 May 2024. And we know that this wasn't deposed to in May 2024. It was deposed to, we think, in October sometime that year, certainly after May, because it was only after the prosecutor had written in September saying, please correct the problem in relation to the 15 cartridges. And that was also one of the complaints that was made by the officers who came to see you. What was your response to that complaint?
Commissioners, my observation when I went through this statement, there's only two scenarios that I think happened here. Analysts are doing their own typing. In the past, we used to have typists, but they resigned, and we no longer we don't have typists. So analysts started to do their own typing. So as they do their own typing, I think what happened is that if the analysts start the case on the 26th of October and finish the case on the 27th of October, they happen to have that habit that they also type a date for the commission of oath up front. So if you check on 8.8, the date which is there was typed when the report was compiled on the 24th of May. Now, what happened now here, after a year or two, you are told that page 3 of 8 has got a typo error. Please correct the mistake. The analyst will go and look for the report on their typing folder and correct the mistake accordingly. But what happened is that they may not go to the last page to change that date. And the two scenarios is that either he may only press print current page and print only the page where he has made the correction and go to the person who initially commissioned the statement and ask them to initial that page and insert that page which correction in the report. Or he may print the entire page, the entire report, without changing the last date on the last page and look for the member who commissioned on their behalf or any other member and give them, because the date is there, the person who commissioned will sign. I'm not saying it is right, but that is what I think could have happened in this instance. That is my submission, commissioners.
While we deal with the commissioning, there's a further concern that I have about the commissioning, apart from the fact that the date doesn't reflect when the affidavit, the corrected affidavit was ostensibly deposed to. The commissioner on both cases, on both affidavits, page 27 for the first one and page 35 for the second, is a warrant officer Marsha. And warrant officer Marsha was the partner of warrant officer Makgotlwe when he attended the crime scene. Is that not right?
That is correct, commissioners.
I'm not sure what the legal consequences of this are, but I would suggest that it is not, that it would be good practice for your section to ensure that the officer who commissions an oath in relation to a ballistics report is not an officer who's had anything to do with that case previously.
Commissioners, now that the evidence leader is mentioning it, I fully agree that it's something that the section has to look at in order to safeguard our processes. Because certainly one may argue that there might be some conflict of interest. The other member already has side to the case. So it's something that we'll have to look into it and try to put some measures to prevent it, commissioners. I accept that, commissioners.
Brigadier, besides the correction that we see, which Advocate Shaskalson took you through just now, in the non-conformance process, what discrepancies did Captain Makhotle himself highlight, and what explanation did he personally give?
Commissioner, the non-conformance is attached. It's handwritten. Firstly, there's a...
Is it the document at page 15?
That's correct, Commissioner.
Maybe you read better than I do. Can you please respond?
In section 1 is the description of the non-conformance. Case examination, Captain Makhotle FSL, completed Lieutenant Colonel Monakali affidavit. Captain Makhotle examined case file with lab number 193051 of 2024 and lab 193045 of 2024. Paragraph 3.4, the examiner states that 2 fired bullets core were received. In paragraph 10.2, the same bullets mentioned in paragraph 3.4 as the cartridge cases. Paragraph 4.13, the examiner states that 1 cartridge case was received. In paragraph 6, the same cartridge case examiner mentioned it as a cartridge. Then they referred to the form that he completed. On ICDMS, the affidavit was scanned and confirmed date 2024-06-2026, and the corrections were made after the scanning and supplementary affidavit was not scanned. They gave a reference number. And then the initial assessment. The error as mentioned above noted. The supplementary affidavit was created and corrected the errors and submitted for scan. So, in short, Commissioner...
Yes, I wanted to say in your own language, can you please explain this? I'm completely lost.
The person who was investigating this non-conformance was just stating the errors as they saw them on the typing error, those paragraphs that we're referring to, where there was an allegation that the 15 cartridge cases were not compared with the AK. So they were mainly, at the time when the complaint came, they concentrated on those typing errors, commissioners.
Can I just maybe follow up on that? If one goes to page 23 of the original statement, the examiner refers under 4.13 to 7.62 times 39 millimeter caliber cartridge case. In other words, an AK-47 bullet cartridge case. And he marked it, he tells what the markings were. And then in paragraph 6, he says he examined the cartridges mentioned in 4.12 and 4.13 and found that they consisted of a primer, cartridge case, bullet, and propellant. In other words, what he should have referred to in 4.13 wasn't a cartridge case, but an actual cartridge.
Commissioner, that's another mistake. Yes, 4.13 is a cartridge, not case.
And he corrected that at page, with a supplementary statement at page 37. And that supplementary statement, which was signed or sworn to on 26 February, corrects paragraph 3, corrected paragraph 4.13, says paragraph 4.13 should read 1 7.62 times 39 millimeter caliber cartridge, not cartridge case. So the supplementary statement corrected that error pursuant to the non-conformance report. And if one sees the reference to paragraph 4.13 in the non-conformance report, which explains, or which had picked up this error. Brigadier, one issue which has confused me is that the non-conformance report refers both to the error in in 10.2 and to the error in 4.13 that we've just looked at. The warrant officer deposed to a supplementary statement to correct the error in respect of 4.13. But in relation to 10.2, he seems to essentially just created a replacement page or deposed to a whole new affidavit. Why would you do, is there any explanation for that? I mean, surely the sensible procedure is just, if you're going to do a supplementary statement, address both issues rather than do the page replacement and present a document that purports to be an affidavit signed in May 2024 when you're doing this all in October 2024, February 2025. Why the two different procedures?
Commissioner, I take note of the observations, and myself as well, I do not understand because they were all identified under one non-conformance. They should have been in one report. So I don't know why he made two supplementary on the same mistake which were identified already, Commissioner.
Thank you, Brigadier. Before we leave these reports, there's one final issue that I want to raise with you, which is that when we consulted with Captain Mkachwa on Friday, he brought the case file with him. And what we found in the case file was an affidavit stapled to the front folder of the case file, which was a third different version of this affidavit of Warrant Officer Makgotle. And what that affidavit did is it corrected the only change that we could pick up in that affidavit was a correction of paragraph 4. So that the affidavit in the case file today, in paragraph 4, no longer refers to Bramley case 140 of 4 of 24, but now refers to Bramley case 149 of 4 of 2024. Do you know anything about this third affidavit?
Commissioner, no, I don't have sight of that. I'll have to investigate and find out.
And before I raised it with you, had anyone even reported it to you?
No, Commissioner.
Sorry, Mr. Skelton, it's not part of our annexes.
It's not part of our annexes because I intended to deal with it with Captain Mkachwa because he's the one who can actually confirm that that is in the case file today.
Thank you.
Is there any protocol that could explain, well, that deals with a case like this? If you want to correct an affidavit, who should you tell? And where should it be reflected? Is there not some sort of log sheet or something that should reflect where it's done?
Commissioner, corrections of affidavit or recall or supplementary, that is all determined by either when you have a complaint from the client, when they check your report, when they discover that there's a mistake. The next course of action will then determine if you have to recall the previous statement and issue a supplementary report. Because in most cases, those are mistakes that are noted after the final report has been reviewed and finalized, scanned through the ICDMS, made available to the prosecutor. And in some instances, that's when such mistakes do happen. So in that instance, that's why we have a non-conformance procedure, which we register and investigate to find out what could have been the problem. Is the problem with the system, or is the problem with the member? Is he or she negligent? Or only investigation can then point out the next course of action, commissioners.
And Brigadier, if there is, let me put the question this way. Assume that there is now a third version of this affidavit in the case file. What should there be in the case file to explain the circumstances in which this affidavit was changed again? Should it be in a log sheet? Should it be in surely something needs to be in the case file to explain what has happened.
I'll assume because the statement must be, if there was an error which was corrected, it must go through the review process again to be reviewed. Therefore, the log sheet for case review, I expect it to be in the case file with the signature of the person who reviewed it.
We sit now in quite an unfortunate situation where a very important murder case is potentially jeopardized by a succession of errors in relation to the ballistics report and a succession of, let's say, curious elements. A statement that has changed several times, sometimes without apparent explanation. I want to put it to you that in order to safeguard the Bramley and Vereeniging prosecutions, this ballistics examination should be redone from the start by a different ballistics examiner who's had nothing to do with it from now. And I just want to suggest to you that this ought to be an exercise that can be done. So let me ask you first. I am assuming that the exhibits themselves, the cartridge cases, the bullets, will still be in sealed evidence bags in your ballistics section, either in the Bramley file or in the Vereeniging file.
That is correct, Commissioner.
And the weapons that were seized at Bramley will also still be in your ballistics section in sealed bags.
No, Commissioner.
Where would those weapons be?
Back at their original station, Commissioner.
Presumably with a proper chain of custody, and one would hope securely at the original stations.
And normally they keep them until the case is disposed of, Commissioner, so they should have them.
At any rate, the test cartridges that were fired from those weapons will be in your section.
They are filed inside the case file, Commissioner.
And those test cartridges have been fired both by Captain Makgotlwe in one case and by Captain Mkachwa in another.
That is correct, Commissioner.
And indeed by Captain Modesani in a third.
And Warrant Officer Kada.
And Warrant Officer Kada in a fourth. So we will have no difficulty finding test cartridges that don't necessarily depend on Captain Makgotlwe's reliability as a witness in this case to be used in this case.
Under the normal circumstances, when a case is re-examined, the analyst will want to testify his or her own test, so that when he testifies, he says, I, so and so, tested the firearm and fired shots and compared them with the exhibits. So hence, re-examination of the entire case, because he cannot use someone's test. You don't know how he fired those tests, what materials they used. You can't testify based on that fact, Commissioners.
So a new examiner will have to get the weapons from the police station, fire their own test shots, and then do their own comparisons.
Our procedure, Commissioner, explain how a request of re-examination is done. And in the procedure, it means it's a fresh start.
But there's nothing preventing that fresh start from taking place at this stage.
It's a discussion, because there must be a reason. In terms of the procedure, you must hear what is the complaint and take it from there. So there must be a discussion regarding that. And for the record, on this particular one, a meeting has been scheduled on the 31st with the prosecutor involved in this case. And only then a decision will be taken after that consultation, Commissioners.
But, I mean, for present purposes, I just want to establish it is possible. If you and the prosecutor, or if that meeting decides they want a fresh start, it is still possible to do the fresh start and to reconstruct a new ballistics examination that will be capable of supporting the prosecution in the Bramley and Vereniging cases.
Commissioners, the procedure is flexible. You might have seen on the news where an accused comes with a private expert, and the private expert says, I want to do my own examination. In that instance, the procedure says, if he has got a court order, he must be allowed, and he will do his examination. So hence I'm saying it's a subject, it's subject for discussion in that meeting with the prosecutor concerning these matters, Commissioners.
Brigadier, the last issue on this report is that Captain Mkachwa will be speaking to, well, various aspects of his examination, and for that purpose he has to bring in the case file as well. Can you authorize him tomorrow not only to bring in this case file, but also the Vereniging case file, so that we can see the reviewer's notes? Because the reviewer's notes in this case file just cross-refer to the Vereniging case file, so the Commission needs to have the Vereniging case file.
It will be made available, Commissioners.
Thank you, Brigadier. Brigadier, the last big topic that I want to raise with you is the success of the ABIS system in showing links in this case. And it's an issue that you tackle from the top of page 22. And before we address it, I just need to emphasize what I said again. I said earlier, which is that you have a statement with all the details in it. You have an infographic with all the details in it. The commissioners do too. But we can't show it publicly because some of these cases are still under investigation. So I'm going to tell you which cases we can refer to in your affidavit and on the infographic. It's 50.1.2 of your affidavit, Littleton case 167 of 8 of 22.
I'm there, yes.
You there? So that one we can refer to.
Yes.
We can also refer to the case at the top of page 24. Santon case 437 of 10 of 2020. And that I understand to be the attempted murder case against Kat Matlala in respect of the attempted murder of his former girlfriend, Tebogo Thobejane. We can also refer to the 3 cases in paragraph 51, the murder of DJ Somebody, the murder of DJ Vintos, the murder of DJ Somebody was Santon case 398 of 11 of 22. The murder of DJ Vintos was Orlando case 220 of 3 of 22. And the murder of Jonga Don Tindleni is Orlando case 93 of 2 of 23. For the rest, I'm going to ask you not to mention case numbers or case anything that identifies the case. But can we first look at the infographic, which is Annexure MNM3. If we can just display it, because even with a lot of redaction, it remains quite a striking picture. So, without mentioning case numbers or cases that you can see on the infographic in front of you, can you describe to the Commission what this infographic represents?
Commissioner, our IB system uses what we call analyst notebook to simplify associations. And they design this infograph, which indicates which case is linked to this case to make it simpler instead of going through the whole paragraph. So as the hits are identified on the match point, the operator will compile. And every time when they discover a new possible hit, you will add on this infograph. The infograph will grow. And at a later stage, they will start to retrieve all those case files that are mentioned here and assign them to an analyst to compare them physically on the comparison microscope to confirm if they were indeed fired in the same firearm as they are represented on the chart there. And in these instances, this is what the operator did for all these cases which were linked to the Vereeniging and the Bramley case. All those cases that are depicted there, they have an association of some sort based on their caliber. For example, the AK-47 is linked to this number of cases that are listed here. The 9mm Taurus is linked to these cases that are mentioned here.
Sorry, Brigadier, remember that you and we can know which cases are linked to the 9mm, which ones are linked to the AK-47. Maybe if you can explain which case is linked, which are the cases, if you can just refer, I think what people seeing the infographics can see is gun 1, gun 2, gun 3. So gun 1 is the 9mm Taurus seized in Bramley. Is that correct?
That is correct, Commissioners.
Gun 2 is the AK-47 seized in Bramley.
That is correct, Commissioner.
Gun 3 is the CZ pistol seized in Bramley.
That is correct, Commissioner.
And gun 5 is, I think it's the Sauer 9mm seized at Bramley.
That is correct, Commissioner.
Gun 4 relates to a different case that has a lot of overlaps, but let's ignore gun 4 for present purposes. So using the references to gun 1, gun 2, gun 3, and gun 5, can you just describe, can you just repeat your description again?
Commissioners, as I was stating here, the gun 1, which was recovered from the Bramley cases, is linked to the only case which I can mention here is the Santen case 437 of 10/2020 murder.
In fact, that's an error in the infographic because it's attempted murder. Brigadier, I'm sorry about that. That is the attempted murder of Ms. Thobejane.
Yes.
So one of the Bramley guns can be positively linked to that attempted murder. Can also be linked, apart from that attempted murder, to another 18 different crime scenes apart from Bramley or Vereniging themselves.
That is correct, Commissioners.
So this single gun has been used, according to what your ABIS system has shown, in 19 different murders or attempted murders, and plus the murder in Vereniging, 20 different murders or attempted murders that this one gun is linked to.
That is correct, Commissioners.
The AK-47, can you describe what your ABIS system has established in relation to the AK-47?
The AK-47, which was recovered from the Bramley case, is linked to other 8 cases, including the Littleton case 167 of 8/2022, attempted murder. And again, the Vereniging case. That is the AK-47.
So that is, this case seized in Bramley was used in the murder in Vereniging and another 8 different murder or attempted murder crime scenes. And 2 of those we can actually mention. The Orlando case 220, which was the murder, 220-03 of 2022, which was the murder of DJ Vintos. And the Santon case, 398 of 11 of 2022, which was the murder or attempt of DJ somebody in the attempted murder of people with him. Gun 5, the Sauer, which links have you been able to establish how many links have you been able to establish to gun 5? I'll point out this is not in your statement, so it's additional to your statement because these were not addressed in your statement.
No, Commissioner.
But if we look at the infographic, what does it show in relation to gun 5?
According to the linkages for gun 5, there were 3 additional firearms or cases that are linked to gun 5, commissioners. And the gun 5 is also linked to the Bramley case as well.
And these 3 cases that that gun 5 has been linked to are all murder cases.
That is correct, Commissioner.
And
one has 2 counts of murder.
And gun 3, the CZ pistol, has been linked to one other case apart from Bramley and Vereeniging.
That is correct, Commissioner. Yes.
So your conclusion in paragraph 51 of the statement was that the 3 weapons seized in Bramley have been linked to 24 other different serious crimes through matches generated by ABIS. That was before you'd run the matches in respect of gun 5. So 24 now becomes 27.
That is correct, Commissioner.
And if you go back to MNM1, you see on Annexure MNN1, 29 hits. And would that be the 27 we've just discussed, plus Bramley, plus Vereeniging?
That is correct, yes, Commissioner.
Brigadier, that is essentially all I wanted to canvass with you. Sorry, that is essentially all I wanted to canvass with you, but I do really want to emphasize the point that I made earlier, which is this ABIS system is extraordinarily powerful. And I don't think you're going to argue with this, but my own submission is that SAPS should be resourcing the section that drives this ABIS section so that it can get the maximum capacity out of that system that it can. You have 3 weapons seized in Bramley over a year ago that have now been linked to 29 other investigations across the country. That's information the SAPS should have had within a week of the seizure in Bramley. They've had to wait for almost, for more than a year to get that information. It's been a lot of wasted investigation time that could have been accelerated if they got that information instantly. You're nodding your head, Brigadier. Is that an agreement?
I totally agree, Commissioners. I totally agree.
Chair, from my side, I have no further questions for the Brigadier.
Brigadier, the last paragraph of your statement, the last sentence there. Accordingly, if the investigators were informed by anyone prior to Prosecutor Kusia's letter of 5 August 2024 that the weapons used in the Vereeniging murder case are linked to various other murders in different cases, the person who so informed them would have had to have obtained this information from a source other than the ABIS system. According to the investigating officers, that is Captain Mokhatle, through your investigations, have you been able to establish what that source is that you mentioned in the last sentence of your statement?
Commissioner, what I can say is that you have a situation where the investigation, through their own investigation, they come across information that case X and case Y could be linked together. And when that happened, they write a letter to the lab and they request us to compare this case and see if there are any linkages. And in that instance, we will simply retrieve those cases from archives and compare them physically. There's no intervention from IBIS. So if I think on this one, there was an instant where probably the IO got some information that the Vereeniging case could be linked to the Santen case. I'm just singling out that request in particular. The Santen case 398-11-2022. And they wrote a specific request for those two cases to be compared. And indeed, when they were compared, a positive was made. So that could be the only way in which a person will know if there's an information that perhaps the same person who is arrested for this case, it could be the same person who committed this murder. Please, can you check for us? Then we say this is a request, we do that, but they are not related to IBIS. So if anyone says that, but we were able to compare this case and that case, I would say if there was an information, yes, it does happen, Commissioner. Maybe that's why this paragraph, maybe it was through that. I'm not too sure if it answers this question.
Yes, I understand the investigating officer's grievance. Their grievance is that it was Mokhahlwe who told them that the weapons seized in Bramley were linked to various other crimes. And they were disappointed when they then received the ballistics report from him, and it did not contain those linkages. And that's when they became suspicious of him.
Given the timelines, Commissioner, he could not have told them. Even if he did, he could not have known. Because we now know that the specimens were acquired when in September and viewed around 2025 and only linked with other cases now. So when the discussion happens between him and the detectives, there was no, and he was not at IBIS at that time. So he could not have known that these particular firearms are linked to so many other cases. I don't know how that discussion came about. Maybe he can answer himself as to the truthfulness of that statement, Commissioners.
Other than IBIS, is there another system that is used by the police that could have made that linkage?
Definitely no, Commissioners. This is the only system that we are utilizing.
Chair, I'm just indebted to Commissioner Khumalo because I haven't addressed this section of I'd lost track of where I got to. But I think the timeline is very important here. We've dealt with the audit trail. And that the key point in that audit trail, Brigadier, would be 6 September 2024, which is the first time that the Bramley Vereeniging weapons were entered onto ABIS.
That is correct, Commissioners.
Now, the allegation of the detectives is that when they met with Captain Mokhahlwe in May 2024, possibly June, he told them these weapons are linked to other crime scenes. And we know that the detectives certainly believed that, because if we go to MNM 5 August 2024, paragraph, this is the letter that the prosecutor writes to various senior police officers seeking protection for the detectives. In paragraph 5, she writes, the investigations also revealed that the firearms used during the commission of the assassination and found in their possession are linked to multiple assassination and serious violent crime scenes. So by 5 August, the prosecutor had been informed that the vehicles had been linked to other crime scenes. Now, that information couldn't have been obtained from ABIS because ABIS would only have been able to give you that information on 6 September. The detectives say that Captain Mogotwe told them that in May, June. He couldn't have got it from ABIS, but there is certainly a possibility that if organized crime networks had infiltrated the SAPS, he may have been tipped off that these weapons are weapons which are involved in many scenes. What's your response to that?
Commissioners, the timelines do not support that assertion.
Well, the timelines only tell you what ABIS would have been able to report. They don't tell you what would have been able to have been communicated to Captain Mogotwe, either from criminals or from members of the SAPS who were in concert, acting in concert with criminals.
I still do not believe that anyone could have had access to this kind of information before the actual analysis even could take place. Whoever made such a statement, maybe they were just making a statement for the sake of it. But that statement is not supported by objective facts, commissioners.
Well, Brigadier, I do need to explore this further with you, because the one set of people who would know where the AK-47 had previously been used and where the Taurus had previously been used were the criminals themselves. And in particular, the people who had engaged the hitmen at Vereniging to perform the hit in Vereniging. You accept that the masterminds, in inverted commas, of the Vereniging hit would probably know where that AK-47 and that Taurus had previously been used. Do you accept that?
If they confess, yes, they will make such a statement or a confession, commissioners.
You see, I mean, you're right. This is an issue that we need to take up with Captain Mogotwe. But it does seem to me that the real significance of the timeline is that if indeed Captain Mogotwe said what the detectives say he told them when they collected their report in May and June, then somebody with links to the organized crime networks must have conveyed that information directly or indirectly to Captain Mogotwe, because he couldn't have found it from ABIS.
Commissioner, I will not comment on that one because I don't know really.
Thanks, Brigadier. Those are all of my questions.
Thank you, Brigadier.
Thanks, commissioners.
Let us adjourn and resume at 9:30 tomorrow.
Thank you, Chair.